Hello, everyone. Welcome again. My name is Rodrigo Viana. I'm the head of the International Affairs Office at FGV Direito Rio. It's a pleasure to have you all again for this last lecture in this series of webinars regarding law and economics. This is the second FGV and Chicago University Forum in Law and Economics in Brazil. This is a joint initiative. I would like to send here, since now, my acknowledgements to Professor Omri Ben Shahab from the Chicago University and to my colleague Maria Lúcia Padua Lima from FGV Direito São Paulo for the effort of making this possible. This is the second very successful edition, and we hope that the third one will be next year in Brazil, presentially with all these great professors and lectures that we had. Well, before we start, I would like to remind you all that you can send your questions to our lecturer of today, Professor Mariana Pargendler, who will be properly introduced by my colleague Maria Lúcia. You can use the YouTube chat to send your questions, then we will be happy to read them. And I would also like to say that all statements expressed by Fundação Getúlio Vargas employees and guests in our online events and broadcasts exclusively represent their opinions and not necessarily FGV's institutional position. We also reiterate that everyone present here agreed to participate in this event of their own free will, and they consented to be recorded in this broadcast, which will be posted later on FGV's official channels and Chicago official channels as well. Well, once again, thank you very much, Mariana, for another participation in our events and broadcasts. It's a pleasure and honor to have you here. You are really represents very well the FGV expertise in those fields. It's really important. We want to make sure that FGV, together with Chicago, can deliver very interesting discussions regarding law and economics, the perspective of many subjects using the law and economics perspective. So it's a pleasure and honor to have you here. And we would like to give word to my colleague, Maria Lúcia, once again. Thanks and congratulations. This is our last webinar. So if you want to check the previous one, please go to YouTube and our FGV channel, and you can see all the contents that were previously debated here. Thanks a lot, and good afternoon to everyone.
Hello, thank you very much, Rodrigo. Thank you for all your presence. We are very happy to do this, our last session, and you do hope that next year will be we have the third edition, but here in Brazil, the presential one, okay? This week, we are discussing the economic analysis of contract law. Last Tuesday, we had the opportunity to attend a lecture by Professor Lisa Bernstein and Professor Brad Patterson from the Chicago University. This Thursday, as Rodrigo mentioned before, we will have a lecture about economic analysis of contract law in comparative perspective by Professor Mariana Pargendler, our dear colleague from the FGV Direito São Paulo. Professor Mariana Pargendler is a full-time professor of law and director of the Center for Law and Economics and Governance at FGV Direito São Paulo. Mariana is a wonderful colleague, and thank you so much for your participation. I would like also to remind again that it's possible to send comments or questions to the Slido link from the YouTube and also from the QA in the Zoom platform. Please feel free to do so, and we like to thank again, Mariana, and please, you have the digital floor. Thank you again.
Thank you so much, Rodrigo and Maria Lúcia. It is a great pleasure and honor to be here with you today. This was a fantastic program. I followed the presentations on YouTube and learned a lot. I think we all missed some in-person interactions, but the content was really outstanding. I have a presentation that I would like to share. see. Okay, I think I've made it. So we'll be talking today about the law and economics of contract law in comparative perspective. So there are basically two questions that I would like to address. The first one is, does contract law matter to economic outcomes? And then the second question is, how do contract laws differ around the world? And here I have two types of divisions that are quite common in comparative law: global north versus global south division, as well as the civil law versus common law division. And if they differ, what are the implications for economic transactions? So this presentation is based on three papers of mine, all of which are publicly available on the web, generally, or on the website of ssrn.com, if you want some written materials about the topic. So now I think, do you see, I need some information now because I see something black, a black square in my presentation, which was supposed to have some content. So now I need to find out. Let me see if I can check with my colleagues if you have the same vision. I'll try to share my presentation again. It didn't look a black. You did see a black. That's so strange. Let me try again. Oh no, it's okay. So I think I will go without my PowerPoint slides because for some reason there was a small technical glitch here. And instead of you reading the content, it looks black. Unfortunately, I'm very sorry for that. So I will stop sharing and tell you what is in the slides. So we'll proceed without slides. That's not a problem. So basically, I want to start with a fundamental question. Do differences in contract laws around the world matter from an economic standpoint? First, I would like to start with a general overview of the field of comparative contract law. So comparative contract law is perhaps the classical field of comparative study. It is the subject of an extensive doctrinal literature by jurists around the world. But this literature is mostly doctrinal in nature. It describes various rules of law, but says comparatively little on the law in action and its economic implications. This is a shame because the great economist and Nobel laureate Douglas North has a very powerful statement that says that the inability of societies to develop effective, low-cost enforcement of contracts is the most important source of both historical stagnation and contemporary underdevelopment in the third world. So there is this view that contracts really matter for economic outcomes. And yet the comparative literature on contract law has paid little attention to the economic implications of different contract law regimes. I think now I will try to say if that it was just bad luck with the first slide or if it was a structural problem with the presentation. Let's see what happens now. If it is a structural problem with the presentation, I will proceed without slides. But let me try one last time before giving up on my slides. Okay, so this slide looks pretty normal. So maybe it was just the first slide. We'll see. We'll see. Okay. There is a large empirical literature on contract institutions. Those works are primarily written by economists, but they are somewhat unsatisfactory for lawyers. They provide various measures of contract enforcement across jurisdictions, but those measures are mostly procedural in nature. They have to do with the time it takes to enforce a given contract, the duration of the process, or the costs of enforcing a given contract claim. There is little concern in this literature about contract rules and doctrines, the type of thing we learn in law school. And I'm thinking here about studies such as the Doing Business report, which is now in disgrace. The project has been suspended, but it is really interesting to think about the different treatment of contract law by, say, the Doing Business report compared to the treatment of corporate law or bankruptcy law. When these types of studies measure, say, investor protection in corporate law, they really care about the rules of law that we learn in law school or that are practiced by lawyers. However, when it comes to contract enforcement, the view of this literature was highly formalistic and insensitive to the rules of contract law and to the potential importance of existing differences. This also raises the question, what does contract enforcement mean? I think sometimes economists think that the term is explanatory. You just give force to the contract, but it is not quite explanatory, because in order to give force in a court to a contract, you have first to determine what the content of the contract is, and there are different theories of contract interpretation. This is one component. It is also the case that every legal system in the world provides some limits to what courts will enforce. There are certain obligations that courts will not enforce for moral reasons, public policy reasons. Some limitations exist everywhere, but the scope or extension of those limitations might vary across the jurisdictions, and this is quite important, but that has not received sufficient attention. And the result is that contract law has been somewhat neglected by the literature on contract law and development. Why is it that contract law itself is neglected? I think there are some relatively bad reasons. One of them is that it is difficult to measure law. This is true. It is difficult to measure law and to compare law across jurisdictions, but this has not prevented scholars and policymakers from comparing other areas of law beyond contract law. So this cannot be a reason why contract law has been left out of the analysis. Another potential reason is that it turns out that law and development and law and economic scholars know nothing about contract law. We know actually this is not the case. Some of the most prominent law and development scholars, and thinking here about Michael Trubilco or Kevin Davis, are also contract law scholars. So this makes this neglect of contract law quite puzzling. So I try to anticipate some of the reasons why contract law might not seem to matter for development. And I would like to rule them out one by one. The first reason why you might not be interested in contract law is because there are no differences in comparative contract law. In practice, contract law is the same everywhere, so there's nothing to study or compare, because it's basically uniform across jurisdictions. This is one reason why you wouldn't want to focus on contract law. Another reason is that contract law might be trivial because it might not prevent parties from doing what they want. So whatever contract law says, it might not be an obstacle. So maybe that's why you don't care about it. Another interesting reason is the availability of choice of law. Even though different countries have their own contract laws, it is the case that you can, at least for some purposes, choose the law of a different jurisdiction to govern your contract. Another obstacle is what I call the definitional problem. What is it that contract law regulates? It might be that some aspects of regulation which might govern contracts are no longer called contract law. This is what I call, if it matters, we no longer call it contract law. And finally, I explore a certain US bias of the literature, in the sense that contract law hasn't been an area that has been the object of significant reflection from US scholars from their domestic standpoint as critical to the country's development, is treated as relatively unproblematic that way. And so there is a sense that the contract law is perhaps empty, highly formalistic, and should continue to be so. So I'll rule them out one by one. So the first objection is the homogeneity. I think there's a title here, the homogeneity of contract laws across jurisdictions. So this is the idea that, okay, I get it. There might be some small doctrinal differences across jurisdictions, but they just mask same practical results. So you can have this idea, which is very dear to comparative law scholarship, which is the idea of functional substitution, that you can have different rules leading to the same practical functional outcome. And the idea also that even if contract laws were somewhat different in the past, there has been significant convergence to the same, most efficient model. And I think those considerations are all true, but they don't mean that there are no persisting differences. In fact, there are still persisting differences, notwithstanding a significant level of functional substitution, as well as recent convergence. Some differences remain. The second objection is that contract law is trivial, the idea that parties can always do as they want. Maybe if you look at contract laws closely, it is made of predominantly of default rules that can be avoided through different wording in the contract. And perhaps the mandatory rules in contract law that do exist, that cannot be, when you cannot agree otherwise, they are actually trivial in the sense that those are rules that all parties would have agreed on if given the opportunity. So it's the triviality hypothesis. And it's also possible to criticize this view because not all default rules are necessarily trivial. There is a growing literature on behavioral law and economics that suggests that default rules can be sticky. Parties are actually attached to the status quo, including the legal status quo, and might prefer the existing default rule over a regime that deviates from the default rule. And another reason is that, true, there are many default rules, but actually mandatory rules are also quite abundant, and they are more abundant in certain jurisdictions compared to others, and that might also be an important consideration. Moving to choice of law, this is the idea that parties can choose the governing law of the contract. Therefore, parties can opt out of quote unquote bad contract laws that do not produce the most efficient outcome. There is some truth to that as well. However, it is important to bear in mind that choosing a foreign law comes at a cost. In some cases, it might require arbitration because national judges might not have relevant expertise in a foreign law question. Arbitration can also be costly, more costly than judicial proceedings in many legal systems, including possibly Brazil. And most importantly, choice of law is not always available. For some types of contracts, choice of law might be unavailable. And for some legal issues, choice of law might be unavailable due to the existence of public policy considerations under domestic contract law. Now I turn to what I call the definitional problem. And this is quite tricky when we think about comparative contract law. This raises the question, what is contract law? And there is a tendency identified by legal scholar Lawrence Friedman to view contract law as the law of leftovers, especially in the United States. What does that mean, this law of leftovers concept? This means that as soon as a field becomes highly regulated, such as, for instance, consumer protection or landlord-tenant relations, then people might not view it as contract law anymore, but as a specialized field. This creates a challenge in engaging in comparative contract law, because if most consequential restrictions are no longer viewed as contract law, it might be very hard to actually compare practical real-world scenarios. So I think this is a challenge as well. But still, contract law, even if understood as a lot of leftovers, still has a non-trivial core that can be compared across jurisdictions, and that might reflect significant differences that have economic implications. And finally, I turn to certain bias in the U.S. law and economics scholarship, which is primarily written, of course, with the background of U.S. contract law. And it is the case that there is greater freedom of contract and greater choice of law in the United States compared to many other jurisdictions. This leads to the idea that there's little meat in contract law. I say the contract law is maybe empty. There are few mandatory rules. That's good. It should remain that way. Contract law is not a development problem, so we shouldn't care about comparative contract law as a core question in law and development, because it doesn't seem to be a huge or an important economic problem in the United States. However, I think this bias is evidently a problem. First, because there's still no consensus on the economic role of contract law, or regarding the idea that contract law should be rather minimalist in content. And also because not all jurisdictions have contract laws that are the same or similar to US contract laws. There are important differences regarding the degree of state intervention in contracts. So whereas contract law does not seem to be a key problem in the United States, or at least was not seen that way from a historical perspective, this is not necessarily the case in other jurisdictions. I don't know what I did now. Hang on. So I'm sorry about that. For some reason, I stopped sharing my presentation. So I believe we are back now. Okay. And I have a Brazilian flag. I want to say a few words about Brazil before moving on. And what I want to say is that in Brazil, there is the perception that contract law matters. And there have been studies by prominent economists suggesting that courts' pro-debtor bias might be an impediment to development. The court's bias against creditors and in favor of debtors have been invoked to explain the extraordinarily high interest rates practiced in Brazilian credit markets. And some scholars have suggested some transactional adaptations to some rigidities or problems or challenges in Brazilian contract law. And I think a very illustrative example is the study conducted by Silva and Furquim. It concerns, it's the McDonald's case, and they show that in Brazil, in the late 1990s, there was a significant incident of devaluation of the Brazilian currency, which generated various problems concerning contracts that were tagged to the dollar. This and other issues created a wave of litigations, of lawsuits filed by McDonald's franchisees against the franchisor, invoking, among other things, Brazil's landlord-tenant statute, and arguing that some clauses in the franchise agreement were void as contrary to public policy and to statutory provisions in Brazil. So there was this wave of litigation at the time. What happened then? Well, as economic theory would predict, if contracting becomes quite costly, you might have more vertical integration. And what they document in the study is that after this wave of litigation, actually McDonald's purchased ended the agreement and started operating many stores, those of the franchisees who sued as its own stores, relying on ownership as opposed to contracting. And the result was that the level of franchise contracts as opposed to owned operations was far smaller in Brazil as opposed to other countries. That is, while McDonald's in other countries rely to a great extent on franchise agreements, after this wave of litigation, McDonald's in Brazil came to rely on its own stores without franchise agreements. So this is one example of a challenge in contract enforcement affecting transaction structure or the structure of economic organization. So here I'm citing Ronald Coase, the great scholar and founder of law and economics, and I'm quoting from his Nobel Prize lecture, and he said that he had come to the conclusion that the main obstacle faced by researchers in industrial organization is the lack of available data on contracts and the activities of firms. And then he goes on to say that he wanted to do something about it and was creating various initiatives. However, I think this remains the most fundamental obstacle today, the availability on data on contracts and the activities of firms. So perhaps the primary reason why contract law has not been studied, and the implications of different contracts laws have not been studied. It's not their lack of economic significance, but it's the difficulty in accessing relevant data to study this theme. And this is a greater problem in some contexts compared to others. In the United States, there is a large literature on real-world contracts. Some of the studies are case studies, and I think Professor Lisa Bernstein, well, she's the main scholar to have produced this type of study. I think I told her that she's on a league of her own in having conducted various industry-specific case studies of contract practices that are based not only on document analysis, but on various interviews. And that is absolutely fantastic. But many scholars who are not Professor Lisa Bernstein, they actually study contracts that have been filed before the US Securities and Exchange Commission, because in the United States, publicly traded companies are required to file their material agreements. So there is, even if it's relative, there is a wealth of data on real-world contracts available to researchers in the United States. And that is triggering an interesting literature on contract practices. However, that type of data is not available in most countries around the world that do not require their public companies to disclose their material agreements. So what I want to suggest here is that comparative differences in contract law might well be very significant. It's an area that should be studied, and similarities should not be taken for granted. But the transactional adaptations to different contract laws are difficult to study comparatively because the problem of data access that goes diagnosed. So going forward in my presentation, I will not be talking about differences in contract clauses or contract structures, but I'll be talking about differences in contract laws on the books and what we can think about their implications from a theoretical standpoint. Okay, so now back to the general idea of comparative contract law. In general, this literature proceeds based on a functional approach. It's very important to recognize that different rules might serve the same function. This is a very central lesson of comparative law generally. There is, however, another lesson or question that we should face. What if the same field of law serves different functions in different countries? And this theme relates to a key aspect of traditional economic scholarship that is currently under attack. So Professor Bruno Salama mentioned this issue during his presentation, and I think it is a critical one, and it will be relevant for my points that follow. So I have coined the idea, the label, modularity approach to law and economics. I claim that traditional law and economics analysis has proceeded implicitly, at least in part, through what I call the modularity approach. What is a modularity approach? It means that every field of law is a separate module, and it has functional specialization. Each field of law is dedicated to one efficiency objective. So under this modular view, the economic role of corporate law would be to reduce agency costs. The economic role of antitrust law would be to improve consumer welfare. The economic role of tort law would be to reduce the cost of accidents. And the economic role of contract law would be to reduce transaction costs. And I would argue that most of the economic analysis of law proceeds under the assumption that the economic role of contract law is to reduce transaction costs. But this gives rise to one interesting question. I mean, is it really this the only economic role of contract law? And is it everywhere? Or could it be the case that in certain jurisdictions, contract law might serve other economic functions? Okay, so I started with this broad question. Now I want to address one particularly famous division or dichotomy in comparative law, which is between civil law and common law jurisdictions. So this is a traditional subject of contract law. And I will be listing here, I list here on this slide, some of the most traditional differences between the civil law of contracts and the common law of contracts. And I will ask the following question: what can we make of those differences? Actually, this was ultimately a paper that was inspired by a student question in one course that I taught at FGV. Professor Maria Lucia organizes wonderful courses in FGV's global law program. And that particular question was asked by a student from New Zealand. I think I was presenting a slide similar to this one, pointing to the differences between the common law, the contract law in common and civil law jurisdictions. And then the student asked, but is there a pattern? Is there a pattern here? Or are those just arbitrary differences that are all over the place? And over time, thinking about it, I came up with a pattern that I would like to share with you. So what are those differences? First, there's a stronger duty of good faith in civil law jurisdictions. There's also a duty of good faith in many common law jurisdictions, but courts are more likely to imply contract terms based on the duty of good faith in civil law jurisdictions compared to common law jurisdictions. This is a relative difference along a spectrum, for sure. It's not an absolute difference. But most differences in comparative law are really relative differences, and that's what I'm talking about here. A second difference is that there's a greater number of mandatory contract law rules in the civil law compared to the common law. So the civil law of contracts is less empty than the common law of contracts. There's greater judicial intervention in interpretation and revision of contracts in the civil law. So compared to the common law, civil law courts are more likely to engage in highly contextual interpretation of contract terms and are more likely to revise contract terms in view of a change in circumstances. Common law courts are more likely to take a highly restrictive, formalistic interpretation of contract obligation and less likely to rewrite contract terms that were freely agreed by the parties. There's also greater enforcement of penalty clauses in the civil law. Penalty clauses, if they are truly overtly penalty clauses, they are unenforceable in the common law, but they are enforceable in the civil law. There's greater availability of specific performance in the civil law compared to the common law. Actually, specific performance is the primary remedy in the civil law, but an exceptional remedy in the common law. And there's greater availability of contract discharge through a fresh start in bankruptcy in the common law than you find in civil law jurisdictions. So this is the question that my New Zealand student posed. Is it possible to say that the civil law is more interventionist, and in the common law is more pro-contract or more laissez-faire. And my question is that we have to be careful in making such a generalization, because what we see here is that the civil law provides greater intervention in the substance of contract terms through stronger duty of good faith, through greater mandatory terms, through greater propensity in intervening in the interpretation and revision of contracts. However, if a contract passes muster under the stringent review, common law also offers stronger remedies for enforcement. So the state plays a greater role in both controlling the substance of contract terms and in offering remedies for breach of contract of those contracts that have passed its stringent quality standards. The common law, conversely, is less prone to intervene in the control of contract terms, but at the same time, you cannot say that in general contracts are stronger in the common law, because the common law is more reluctant to offer strong remedies for breach of contract. So there's lesser intervention in the control of contract terms and lesser intervention in the remedies offered by the state for breach of contract. So this is the picture that I offer here. And this is something important for policymakers and reformers to bear in mind, because what it means is that different features of contract laws that have been treated as arbitrary by the literature, they are actually not arbitrary. They find a more or less coherent whole or coherent set. So convergence across one of those dimensions might make the overall picture different, rather than push toward greater functional convergence. Now I leave behind the civil versus common law dichotomy, and I want to explore, and this is recent work. I have a paper on contract law and inequality, a working paper. It's available online. It is co-authored work with Professor Kevin Davis from NYU. And we explore differences. We are arguably the first to document certain differences between the contract laws of developed countries and the contract laws of developing countries. And I'm here using on the slide the expressions global north versus global south. We started this project by noting the general view that contract law is not generally concerned with economic inequality. This seems to be conventional wisdom, but we'll show that this conventional wisdom is flawed. And the second view, which we'll also argue is flawed, is that contract laws of developing countries do not differ systematically from those of developed countries. And even though some scholars in passing mentioned that maybe there are differences, they never spell out what they are, which is, and therefore the general literature proceeds on the assumption that global north versus global south is not a relevant division for purposes of comparative contract law, and that led, of course, to policymakers thinking about comparative contract enforcement exclusively in procedural terms. So this is something we would like to challenge here. So in this project, we argue that contract laws of at least certain developing countries are distinctly heterodox. So what we mean by heterodoxy here. Heterodoxy, for our purposes, is defined as overt attempts to achieve distributional objectives, such as tackling inequality and protecting disadvantaged groups through contract law. And we approach this theme by offering case studies of South Africa, Brazil, and Colombia. So before proceeding, I just want to make a few caveats about things that we do not claim in this project, and this is quite important. We do not claim that contract law heterodoxy prevails in all developing countries. Actually, we don't think that is the case. We also don't claim that contract law heterodoxy is absolutely dominant in the contract laws of the countries that we do examine, South Africa, Brazil, and Colombia. We also do not argue that contract law heterodoxy is effective in achieving the intended distributional objectives. Rather, we claim that heterodoxy exists in those countries, and we suggest that it is likely influential from an economic perspective in terms of shaping transaction structures, irrespective of whether it is effective in achieving the intended distributional objectives. We make no claim in that regard. So in terms of scope, our analysis does not cover employment and labor law. In Brazil, we call that Direito do Trabalho. It does not cover Direito do Trabalho. Actually, the literature documents already documents the intended use of labor and employment law to tackle inequality, as well as significant variation in the uses of labor and employment law to tackle inequality. It's important to bear in mind that the exclusion, that actually it is probably the case that employment and labor law in Brazil is much more heterodox than Brazilian regular contract law. So the exclusion of employment and labor law likely underestimates the degree of contract law heterodoxy in developing countries. So a few additional considerations. It's important to bear in mind that the distinction between orthodoxy and heterodoxy is likely a continuum rather than a strict dichotomy. It can also be difficult to distinguish them in practice because it is the case that certain orthodox justifications for a given result and some heterodox approaches to a given case might lead to the same result. So it can be difficult to distinguish orthodoxy and heterodoxy across a wide variety of cases. One could also argue, and this is an important point, that it is not that the laws of developing countries are different, but rather the factual scenarios of developing countries are different. So even, and this is quite plausible, even the application of the very same rules in developing countries and developed countries might lead to different results because of the differences in the underlying fact patterns without talking about any differences in the law. And I think this is certainly the case, but we argue that there is more than that. Beyond differences in the factual patterns, we also have differences in the formulation of the law and of its justifications. And it's also important to bear in mind that contract law heterodoxy is likely not a unitary phenomenon. Heterodoxy in Brazil is quite different from heterodoxy in South Africa, and that's different from heterodoxy in Colombia. So there are probably varieties of heterodoxy. But in this project, we are more worried about suggesting, pointing to the existence of heterodoxy rather than with analyzing the particular varieties of heterodoxy. So what is orthodoxy against which heterodoxy reacts? Well, orthodoxy is the idea that contract law is, we define it broadly, contract law is concerned with autonomy or efficiency or equality in exchange, but not with distributional objectives. The idea defended by orthodoxy is that redistribution through fiscal policy is more legitimate than the incorporation of distributive objectives in contract law for a variety of reasons. It is more accurate and predictable. It is more comprehensive. It is more efficient. It does not lead to the problem of avoidance of distributive contract law rules, and also the problem of interdependence of different parties, which in these problems 4 and 5 go to the fact that even if you want to achieve distributional objectives through contract law, it is harder to do it. Okay, so maybe that's one reason why you might want to avoid it altogether. So we begin by examining the case of South Africa, and it turns out that contract law in South Africa must conform to constitutional values, including the African value of Ubuntu, which relates to a concept of human solidarity. However, individual contracts are not subject to constitutional scrutiny. So Ubuntu affects contract law generally, not contract clauses in particular. And here I have a definition of Ubuntu as an African concept, which emphasizes the communal nature of society, the idea of humaneness, social justice, and fairness. So this is one example of heterodoxy in action. So in this particular case, the issue in question was whether there were limits on prejudgment interests that applied after the initiation of litigation. And the court noted that to many credit consumers who fall on the wrong side of this country's vast capital disparities, astronomical interest may mean the difference between economic survival and complete financial ruin. It cannot possibly be said that for our democracy to be meaningful, it is only fitting that those previously denigrated by racism and apartheid, confined to the fringes of society and stripped of dignity and self-worth, must also enter the terrain of meaningful, substantial economic activity. And the court understood that those important distributional considerations should affect its decision to limit the prejudgment interest applicable to litigation in South Africa. Heterodoxy in South Africa does not apply to all cases. One contested case in which it was ultimately not applied was in a case concerning the rights of franchisees to renew a franchise by disadvantaged business. And the court here said that to hold that the failure of a Black Economic Empowerment Initiative financed by the fund renders the enforcement of the renewal clauses deleterious to the constitutional value of equality, would increase the risk of contracting with historically disadvantaged persons who benefit from the fund. So in this particular case, even though the court was highly sensitive to the problem of historical inequality and injustice in South Africa, it applied, in other words, the economic rationale that some interventions might end up hurting the people they were designed to help. So the court ended up sticking with the orthodox approach of enforcing the contract as written. Well, for those of you who are lawyers in Brazil, we know that there are in our context significant debates about how much contract law should take into account concerns about solidarity, social justice, human dignity, the social function of contracts. If you just do a simple search in our court databases, we can find a significant prevalence of rhetoric in terms of using appeal to social justice, human dignity, the social function of contract in a variety of disputes. So we see this type of rhetoric with great frequency. But then one question is, do we also see different outcomes? And we claim that we do see outcomes and different outcomes in some cases. There are some cases in which the ultimate result achieved by Brazilian law is different from what you would expect in other jurisdictions. Two examples here. In Brazil, we have the so-called problem of distratos, or we could call, there's a recent statute on the topic, but and which arguably has mitigated this problem, but that is the issue of exit rights in contracts for the acquisition of housing. So basically, courts have ruled that consumers can always terminate contracts for the acquisition of housing subject to a certain penalty, a fixed amount, not expectation damages, but a fixed amount that was previously established by judges, a standard 15% of amounts paid, and is now regulated by statute of up to 50% of the amounts paid. Judges have also imposed symmetric penalty clauses, saying that if one party imposes a penalty clause on the other for the other non-performance, that same penalty clause should be applied with respect to the other party, irrespective of the explicit lack of provision in the contract. There has been a backlash against contract law heterodoxy in Brazil. We face the new law on economic freedom, and it's hard to understand the new statute on economic freedom, Lei da Liberdade Econômica, without appreciating it as a reaction to contract law heterodoxy. So it says, for instance, that judicial revision of contracts must be minimal or exceptional under an orthodox approach. You would assume that judicial revisions of contracts are minimal and exceptional. Why is it necessary to say that? However, it's important to note that even the law on economic freedom as a reaction against heterodoxy in Brazil is more or less circumvented by its own terms. It does not affect consumer contracts, which are fertile ground for heterodox approaches in Brazilian law. And it also says that the strong presumption against judicial rewriting of contracts only apply to paritary and symmetrical contracts between merchants. So even contracts between merchants, we are not deemed to be paritary and symmetrical, do not benefit from the same presumption. So it is a reaction against heterodoxy, but it's a more or less timid reaction against heterodoxy. And shortly after the new law on economic freedom, we had the COVID-19 pandemic. And I've had some student researchers study this topic, and they have found significant levels of judicial rewriting of contracts following the COVID-19 pandemic. So what we find interesting about this project is that even though in Brazil, this issue of social justice and contracts is viewed as a Brazilian issue, it is not a purely Brazilian issue, but it appears with different contours or shapes in other developing countries as well. So in Colombia, the Colombia Constitutional Court appeals frequently to the right of a vital minimum health, human dignity, and inequality in adjudicating a variety of contract disputes. Those are special actions that reach the Colombian Supreme Court through the tutela remedy, which is available by subjects of special constitutional protection, the elderly, ill, disabled, female heads of households, persons earning less than the minimum wage. And the courts have invoked the social values of the Colombia Constitution to impose restrictions to the termination of certain insurance contracts against such vulnerable subjects, to provide narrow interpretation of coverage exclusions, to mandate the continuous provision of water, among other cases. What about developed countries? Okay, so the claim of the project is that they are more orthodox developing countries, at least some of them, South Africa, Colombia, Brazil, more heterodox. But it is possible to view some elements of heterodoxy, even in US contract law. A classical case is the case of Williams versus Walker Thomas Furniture, which concerned the enforcement of a very broad security agreement against a woman on public assistance and responsible for 7 children. So the court in the case provided relief to this woman on orthodox grounds, arguing the absence of meaningful choice and terms that are unreasonably favored to the other party. So appealing to orthodox notions of justice in exchange. However, the judge of this case, in his extrajudicial writings, explicitly discussed the case as part of the law of the poor. There was a similar case in which he was involved concerning the warranty of habitability, similar in that in his writings, he discussed that the case was ultimately about racial and class discrimination, and that he sought to use contract law to ameliorate the injustice in the way many of the poor were required to live in the nation's capital, and arguing that poor housing was detrimental to the whole society, not merely to the unlucky ones who must suffer the daily indignity of living in a slum. So we might have some covert heterodoxy masked through contract law orthodoxy in some important US contract law cases, even though they are far rarer than similar cases we encounter in Brazil. In continental Europe, there's also greater concern with consumer protection compared to the United States, though much of consumer protection can be fairly consistent with contract law orthodoxy. Compared to the United States, there's greater support for justice in contract law from scholars, and there are few cases of horizontal effects of constitutional principles in contract law that place some countries in the European Union perhaps in an intermediate position between the more orthodox US approach and the more heterodox approach in developing countries, although those cases are so rare and exceptional that the orthodox qualification arguably applies to continental European law as well. Well, recently we had the German the COVID-19 pandemic, which triggered an emergency legislation in Germany. So that right in March, there was a statute on mitigating the consequences of the COVID-19 pandemic, especially of the period of lockdown. And it's interesting to see that there were changes in contract law. They were temporary changes, but they appear to be quite concerned about distribution. because consumers were allowed to refuse payment of essential services if there was risk to their subsistence or that of dependents. And relief was available to micro businesses provided that it did not endanger the subsistence of creditors and dependents. So we saw here in this piece of emergency legislation that the availability of remedy in view of the COVID-19 pandemic was very clearly contingent on the wealth and welfare impacts of the parties, making it a relatively heterodox contract law response. So there's some limits of contract law heterodoxy. One idea is functional convergence, which would be, okay, so contract law in the United States is fairly orthodox, but there's greater relief, for instance, of contract obligations to people in need through bankruptcy law, or in many countries, contract law is fairly orthodox, but the tax and transfer system does a better job of ensuring an equitable distribution of wealth in society. There are limits in terms of comprehensiveness. The very poor, the poorest of the poor, don't have access to contracts of a sufficiently large stake so that they could even benefit from heterodox approaches. There are obstacles evidently in access to courts as well for the poorest of the poor. And there is the issue of avoidance, that parties might be able to structure their economic activity in different ways, such as, for instance, through vertical integration and business groups, so as to avoid the distributive impact or potential inefficiencies of contract law heterodoxy. When we could ask, why is there greater heterodoxy in developing countries? Perhaps because there is significant inequality. There's failure of the fiscal system in addressing such inequality, and therefore distributional responses through contract law seem to make more sense and are perceived to be more legitimate. There is one question, and I want here to go back to the idea of the crisis of the modularity approach to law and economics. And we know there's also a growing concern about rising inequality in the developed world. So one question that I would like to leave open is whether contract laws in the global north might become increasingly heterodox as well. So I would like to conclude with a methodological implication of looking beyond the usual suspects in comparative law and contract law to also look to a wider array of jurisdictions to be examined. I think there are important lessons to be learned from developing countries about what contract law is about, its function, and its potential impact. I think there are unique factors shaping contract laws in developing countries, and there are interesting lessons for practitioners, contract theories, and scholars in line development and line economics. And with that, I just want to add with a big thank you for the opportunity to share my research with you today.
Thank you so much, Mariana. Very, very interesting lecture. It's interesting because usually from an economic point of view, contracts would be related to transaction costs, as you mentioned, but also many times also to mitigate economic uncertainty. You know, contracts it's viewed as a base of the economics in a market economy. You know, a decentralized economy must have contracts and, of course, regulation as a consequence. But it was a very interesting approach we developed this afternoon. Thank you so much for your wonderful participation. And I do hope you have enjoyed this great opportunity. And I would like to invite you to join us again next year in the third edition of the Chicago FGV Forum in Law and Economics. Probably you have this here in Brazil. And once again, thank you so much, Mariana. Thanks so much, everyone, for your presence here this afternoon. Bye-bye. Thank you.